Okay, so today I want to talk about a charging lien case. A charging lien is a way that an attorney can have a security interest in the proceeds of a case that they've handled on a contingent fee basis or in which they're owed money. It comes up in the business divorce cases that I do involving personal injury firms, lawyers and personal injury firms, and other kinds of matters in which there is a present interest in a fee to be paid in the future. And usually that's personal injury and divorce cases. And the reason for divorce cases is that there's going to be a property settlement later, a house is going to be sold, and assets are going to be liquidated, whatever it may be, and lawyers look to get paid from the proceeds of the case. But it's important in business divorce cases involving attorneys and breakups of law firms, because so much of the value of a firm is often tied up in the fees that are going to be earned in matters that they're presently handling. So I think this case is interesting because it first of all involves federal court, and the law on federal court enforcement of charging liens or attorney lien cases is less than clear. It just doesn't come up that often. And it raises some interesting jurisdictional issues, and it just is, I find it very interesting. So here you have a case in which it involved union employees, and they had a claim against the union and the city, and they initially lost. And the plaintiffs then filed a notice of appeal on their own, pro se, without a lawyer. And after the appeal had been filed, a lawyer came in, and so here you have a lawyer named Ryan Paddock, and Ryan Paddock comes into the case, and the clients have lost once, but they filed an appeal, and he steps into the appeal, and he handles the appeal, and he gets a reversal. And the case gets sent back to trial. He works on the case for what would appear to be a year or two, and he takes a number of depositions, 24 actually. He went to oral argument on a couple of occasions, went to settlement conferences. But when it comes time to get expert witnesses, Mr. Paddock can't afford to advance the cost. So he tells the clients this and tells them that they can, if they want to replace him, he'll understand. And they do. They bring in a new lawyer by the name of Thompson. Thompson comes into the case and finishes it out. And about 2 years after that, it settles. It settles for $380,000. Thompson came into the case on a 35% contingent fee, which means that there's $133,000 to be paid to the lawyers. What happens in these cases is that when a lawyer represents a client and pursues an affirmative claim on behalf of the client, the lawyer has rights to the fees in that case. And the obvious example is the personal injury case. It's the lawyer's representing the client in an auto accident case for a third of the recovery. Lawyer gets paid only if the client gets paid. And if the client replaces the lawyer, settles the case on their own, or something else happens, the lawyer has an ongoing interest in the fee. And it's not just a contractual right to get paid. It's actually a security interest, like a mortgage. It's a lien, and it attaches to the property. Most states have some sort of charging lien mechanism in a statutory form. In New Jersey, where I practice, and in New York, where I practice, the legislatures have adopted laws that give lawyers the right to assert a lien over the proceeds of a recovery. There's also liens that can arise as a result of the contract and the expectation that the parties are going to be paid from the proceeds, and those are often referred to as equitable liens. So you have a circumstance, for example, in which the lawyer and the client sign an agreement that says, I'm going to receive a portion of the recovery, I'm going to be paid out of the recovery, and that creates a security interest of the lawyer in the proceeds of any settlement or judgment, any money that's generated by the case. And it's important to recognize that the lien laws are, generally speaking, found in state court cases and enforced in state court cases. And it's not so clear what happens in a federal court case, and particularly not so clear what happens when a case is brought under federal law. When the case is one that is in federal court because you have parties from different states. It's a personal injury case involving a driver from Pennsylvania and another driver from New York, and they have an accident, and Pennsylvania wants to sue New York. They have its diversity jurisdiction, and if as long as it's more than $75,000, you can bring that in federal court. But there are also cases that come up under federal law, labor laws, security laws, whatever that may be. And in those federal cases, there's federal jurisdiction, and there is no federal charging lien statute. For example, in New Jersey, there's a charging lien statute, and the charging lien statute says that you have an interest in any action in the proceeds of a case as long as the lawyer has filed a pleading for an affirmative action for that. And that lien can be asserted at pretty much any time. Typically, they come into the case after it's been settled or gone to judgment. But one of the big issues that has come up is, do you have to assert your lien before the case settles? And in New Jersey, after some litigation on the issue, that the Supreme Court held, no, you don't. Basically, if you have a charging lien, you can bring your charging lien at any time, and there's a process for it. But it's been less than clear about what would happen in federal court. And on top of that, you have the gloss of the fact that federal courts are courts of limited jurisdiction. They don't have the ability to hear any case at any time. And this is critical for this particular case, once a case is resolved, unless something is done to keep the jurisdiction in the federal court, it's over. And so you have cases in which parties were involved in a lawsuit. It was in federal court. There was federal jurisdiction. They settled the lawsuit. And then there's some kind of a settlement agreement, and there's a breach of the settlement agreement. You would think that they just go back to federal court to enforce the settlement agreement, but that's not the case. If it's a settlement agreement, it's basic contract, and unless there is some new independent basis for jurisdiction, or unless the parties have reserved the jurisdiction of the court to enforce the settlement agreement, you're done, you're in state court. You have a situation in which the case settled, and then after the settlement, the first lawyer filed an action to intervene in what was then a closed case in order to assert the charging lien. So it's interesting because the court drew a distinction between its ordinary jurisdiction and what it refers to as ancillary jurisdiction. Gist of the holding is that ancillary jurisdiction is much broader. So what you have in this is you have a decision, and this case is from the Third Circuit Court of Appeals. You have a Third Circuit case that says, in the first instance, lawyers can intervene and pursue rights to be paid out of the proceeds of a case that arises under federal law. And second, that the court has broad jurisdiction to enforce those rights, even if the case has been settled. There might not otherwise be a jurisdictional basis for this case in federal court. Here you have a circumstance in which lawyer number two argued that it was too late. The case had been settled. The court no longer had subject matter jurisdiction. And if, in fact, lawyer number one claimed a right to a fee, lawyer number one had to bring its action in state court. The Third Circuit disagreed. And the idea is that this ancillary jurisdiction, which is sort of a unique creature, it's a jurisdiction that arises out of the fact that the court is a court, and the court has to be able to manage its affairs. And then what the court says is that here, this ancillary jurisdiction that exists in the federal court gives it inherent power to enforce its judgments. And that inherent power extends to the disposition of fees. In a case that's before, in a dispute between fees that arise out of successive lawyers, which happens with some frequency. And one of the things the court says here, it stems from the proposition in this ancillary jurisdiction that the court acquires jurisdiction over a case or controversy in its entirety, and as an incident to the disposition of the dispute that's properly before it, it may exercise jurisdiction to decide other matters raised by the case over which it would not have jurisdiction were they independently presented. You couldn't normally bring this claim in federal court without some independent jurisdictional basis, but because it's tied to an already ongoing case, you can. The question of the division of fees, the Third Circuit held, was part and parcel of the ability of the court to enforce its judgments. The other thing that had come up in the case was that the first lawyer said that its share of the fees, which was $55,000 more or less, ought to come from the portion of the recovery that was intended for fees. And the second lawyer said, no, the client should pay it. The court, not surprisingly, came down on the idea that clients shouldn't be billed twice for the same work. They shouldn't pay twice for the same work. And that if the fee was a contingent fee matter and there was a pool that was created by the contingent fee of money, so I should say a pool created by the settlement of the matter in a contingent fee case, there was a certain amount of money that was set aside for the fees, that the lawyers would have to divide that. A client has an absolute right to fire a lawyer, change lawyers, to choose its own counsel. However, the clients don't have a right to avoid paying for the work that's been done. What is also clear is that the clients aren't going to be paying more in the end than they would have paid if they'd stuck with the lawyer all the way through. So if the fee was 35%, 30%, 20%, whatever it may be, barring some difference in the fee structures between the two, that's the pool of money. So, interesting case, interesting for its position on ancillary jurisdiction, the breadth of the district court's ability to pick up and decide collateral matters. Interesting for the manner in which it does, in fact, permit lawyers who are handling a federal court or federal law matter in federal court on a contingent fee basis to secure a security interest in the money that's created by their work. If you have any questions, suggestions, other topics that you'd like to see discussed, please leave a comment with the video or send an email to me through my website, my blog at www.thebusinessdivorcelawyer.com. You can contact me through there. Thank you.